Hey, Nate here. Welcome to the live stream. I'm usually behind the computer making sure your comments come through as you ask them so that the lawyers can talk about them. Before we hop into the live stream, I just want to let you know of something that is really cool that we offer completely free. It's a physical version of a book written by attorney Matthew Hill that talks you through the entire VA disability process from beginning to end. The link is going to be put in the comments right now by me, and it's also in the description. I highly recommend you click the link and claim your free book now. I cannot stress how much this is going to help you. So if your question isn't answered today, it could be answered in this book that we will mail to you completely for free. That being said, let's go ahead and get this live stream started. We're going to go through the questions in order as they come. And if we don't get to yours, we apologize, but maybe we'll be able to get to it in the coming weeks. Thank you so much for joining us. And now it's time for the lawyers to answer some questions.
Hey folks, attorney Matthew Hill with Carol Ponton. It's good to be back, Carol, in person.
In person.
We haven't been able to do this in a while. Thanks for coming for our Q&A on VA disability benefits. Got a little bit shorter of a show today, so I want to jump right in and let's just go with our first question now. Reginald, good to see you. If I had chronic sinusitis, rhinitis, sleep apnea, and RAD, does that become a bilateral? Issues of the head are not bilateral. That's really kind of an interesting thing to put it because I can see you've got cavities on both sides of your face, and it's kind of tinnitus is the same thing as is hearing loss, and that even though it ostensibly affects both sides of the head, they don't consider any of those to be in the bilateral. Interesting question.
Deep thinking. Keep it up.
Yeah, I like it. Yeah, being creative. Lavender, good to see you. Have you ever heard of sleep apnea from Tara? Thanks. So that would be sleep apnea due to some kind of chemical exposure.
Yes, so far I haven't, but that doesn't mean it's not there. I just don't recall having one.
I haven't had a case like that. I've had a lot of cases where we're claiming sleep apnea secondary to something else, and all of a sudden they do a Tara compensation exam, which
is a denial.
Yeah, and then just totally worthless. But no, I haven't heard of any directly caused by that. Stampede 77 part 1. Hello and thanks. I'm 100% temporary for eye cancer. VA re-examines me every 6 months for the past 2 years. This last time they closed my case 1 week prior to my scheduled CMP. They again rated me 100% temp, contacted my VSO, and she contacted the VA, and they reopened the case due to their error. However, not sure how this will impact my chances of 100% permanent total. Part 3. I have other ratings, and I know if they rate me at 30 or 60% on the residuals, I'd be 100% permanent total. But I believe they're waiting until my treatments lessen for a lower rating. Thanks.
Well, they can't give you permanent total based on something that they know might change, which is cancer if you're getting treatment. And I think that's really the real reason, don't you?
Yeah, if he's getting treatment. Interesting though, if the residuals alone would give him 100%.
Right, but I've seen that.
Do that either.
No,
so
they always wait.
I guess they would consider that pyramiding to give them both residuals and 100% for cancer. So
right.
It sounds like you're in a hurry up and hold pattern here.
Yeah, I'm sorry, but that's the way they do it.
Jess Will, how does an examiner said that used evidence to make my decision, but the progress note from the doctors were never written or entered into my records? Really, the doctor never wrote my progress note.
Are you saying that it said used evidence and noted the doctor's information? Do you think that's what he's saying?
Yeah, I don't know. I can't tell on this if they thought the doctor. I'm not sure what.
Remember, it's supposed to say exactly what evidence they used on the decision. So if it said they used a doctor's evidence, then they would put the date of the doctor's statement or medical records. So I'm not really sure what you're asking here, but if they just say used evidence and don't refer to anything specifically, then you can assume it probably wasn't in there. They're supposed to list specifically what evidence, including the dates of those medical records.
54 nights. I filed a presumptive claim. Can the VA give you a rating decision without giving you a CMP exam?
Yeah.
Yeah, if your medical records are clear enough to give you an accurate rating, they can. Timothy, I got my CMP exam and rating decision emailed to me. Must I wait to file a higher level review until I receive a notification in the mail so I can get the notification date off the letter? Also in section 18A, part 2, VA form 200996, do I just put increased rating for my bilateral foot drop to see attached addendum that will point out my argument for the increase? Is it okay to add loss of use as well, since my evidence supports this based on not being able to push off one foot? Basically means I have no remaining function on that foot.
Can you go back,
First
Nate,
one?
so we can start? Okay. Do you always have to wait for an NOA that, okay, so the VA makes a rating decision, but then when they finalize it, they send out what we call the notice of award or notice of action. And until that's done, there's no final decision. There may be a rating decision there, but it's not final. And they can withdraw that rating decision, which they do many times. So no, you can't file an appeal until that notice of award or notice of action actually is published. Okay. And what was the next one? And yes, you would put on there exactly what you were saying they didn't give you that they should have gotten you, that you're entitled to an increased rating for your foot to include, and I would put bilateral foot drop and loss of use of foot.
Yeah.
Let's see if there's another question that we didn't get. I think that answers it.
And so if you are putting an addendum, make sure you put that in that section, see addendum, okay? Because what they'll do is they'll take the letter apart and lose the addendum. So make sure that says that in there.
Yeah.
And first to 2, working on a first-time disability claim for my husband. Marine, Camp Lejeune, 82 to 84, just diagnosed with prostate cancer, is presumptive under PACT Act with all reproductive cancers. But prostate cancer is not presumptive for Camp Lejeune. Already did the intent to file, wondering if we should wait to see the surgeon next month or submit what we have now and the rest after the appointment.
You always file the claim. You want to get that started.
Bladder, kidney, prostate are all considered presumptive under the PACT Act. All reproductive cancers, yet of the 3, only prostate is excluded from presumptive water exposure. Makes no sense.
Can we go back and start with 1 again? Because this is a working on claim. Okay, diagnosed. Okay. Next, prostate is not presumptive. Did the intent, Camp Lejeune, did the intent to file, wondering if we wait. No, you don't wait to file the claim. And then.
Yeah, even if you have your doctor say something and get a letter from your doctor, they're going to send you a C&P exam anyway. So just get the process started now. Hopefully they get C&P out of the way. You know, we could have a favorable C&P. You don't know. But when you go to the doctor, present whatever evidence you have to say, look, this is what was in the water, TCE, PCE. It was highly concentrated from 82 to 84, and see if you can get a nexus from the doctor on that.
And make sure you put that, everything you get to the doctor, you put in the record. Everything that you take to the examiner, you put in the record as well, okay? I don't know why. I agree. It makes no sense that prostate cancer isn't included.
This is not the land of the logic. Sherman, did a sleep apnea claim 2 years with the BVA, still waiting. 8 months ago, did a new sleep apnea claim, got service connected 2 months ago. What happens to my BVA claim?
They'll dismiss it.
Yeah.
The problem is, did you get the service connection for sleep apnea back when you filed the claim 2 years ago, or did you just get it when you filed 2 months ago? And that's what the BVA has been doing that is upsetting. They will dismiss claims that were filed years ago, but the person just got granted in the last 2 months or so under a new claim. So that's what I'll guess they'll do. They'll hold it and then they'll dismiss it because they say it's already been granted. And then you need to appeal for an earlier effective date if they didn't give you that date back then. So don't let this decision go by without filing for an earlier effective date.
The one that granted it.
The one that granted it.
Okay, Sharon, your office referred my case to a law firm. As a result, I was awarded TDIU within 3 months of them taking my case. I'm currently rated 90%, and the firm is still working to me to get 100.
Great.
That's great to hear. Thank you so much for the referral. I enjoy and appreciate these live chats. I learned so much and pass the information on to other veterans. Again, folks, I mean, that's, we get a couple thousand calls a month, and we can take 70, maybe sometimes 100 cases a month, just as far as capacity reasons. But we see so many cases that are meritorious that deserve to be fought for. And that's why we try to find other attorneys out there that we trust and folks we know will do a good job. So thank you so much for letting us know that. It's always great to hear that our partners are doing a good job too.
And remember, just because we don't take your case doesn't mean anything. this month I kept saying, oh, I can't take another case. And then I would take another case. And then I had to start referring them out because we can only do a good job on so many. So please realize when we refer a case out, we think it has merit, but we're just overwhelmed at that point. Each month we can only take so many in, but y'all have good cases and we want to make sure you pursue them.
Alan, if your claim has been deferred, is that a positive result?
It means nothing.
You have no idea, unfortunately.
It just means that whatever they think they need to make a decision, they don't have. And until they get it, they're not going to make a decision. So often that means they may send it out for a medical opinion, another CMP exam, or we really don't know what they're waiting for. They don't let us know.
Yeah. Yolanda Fergus Adams, good to see you. VA concluded I had a toxic exposure, PFAS in JP 5, probably JP 4, at Shepherd's Airport Base in '82 when there's 6 months of tech school. I had 2 rare autoimmune disorders, TSP and Sjogren's. Outside doctors have said related to toxic exposure, but won't put into writing. How can I tie this to other conditions too, the exposure? Also, can you receive Social Security disability and VA benefit at the same time?
Yes.
Easy. Yes. If cannot work due to the injury not related to your VA disability. Yes. So just to answer that real quick, just because you're disabled for one reason doesn't mean another reason can't be completely disabling. So if you have a non-service related back that's completely disabling, yet you have an autoimmune disorder that's completely disabling, either or could keep you from working. So that doesn't matter. If you paid in the Social Security system, then you are eligible for those benefits.
Right.
As far as getting, I think, what do you think here?
All right. I think the problem is we always have to get our own independent medical exam for these because they usually want to approve them. The best I think you can do is to go to Google and Google all of the medical treatises that tie the different diseases that you have to the exposures that you have and submit them. And the problem is most of these examiners won't look at them but they are supposed to. They have to give a reason why they don't accept that. And they also need to give some medical treatises that contradict that. So at least that puts them on the defensive. Right. Okay. So I at least do that. I worry it's really hard if you don't have an independent medical exam. And unfortunately, a lot of doctors just won't get involved.
So you want to take those treatises to the doctor, but you also want to file them in your record with the VA because just because you take them there, they won't get into your file. And
then when you get your CMP exam back, and if it says not service connected, not related, then you need to I would file a duty to assist in the higher level review and say, these medical treatises say it's related. This was an inadequate opinion.
It didn't discuss it, right?
It didn't discuss it. It didn't say why these are inaccurate. And that's
not applicable to
not
you.
applicable. And that's the best I think you can do without your own independent medical exam. It's going to be hard.
Cynthia, part 1 of 2. I got service connected for IBS at 30% and then filed for GERD. I never got a letter saying GERD is service connected, but on the VA portal, it shows GERD is lumped in under IBS. Is that a problem for the future? Should I request a letter stating that GERD is service connected? I'd want to see the rating decision.
Yeah.
I'd go back and maybe look at the rating decision and see if it lumped it in the reasoning when it talked about granting IBS. I don't know. That's strange. That should
it should show up somewhere as in a rating.
Yeah.
That the veterans who have the total online experience where they have their medical records, they have their VA claims, you have such an advantage over other people because you can actually go in and see all of this and you can see exactly what they've said, what's on there, and you don't have to wait. You don't have to beg the VA for things. So I do encourage you. I know it may be more difficult to get. I don't know the name of it. I know you can get one that's just your medical records, but there's something that covers everything. And I understand it covers all the VA medical records that places you've ever been. So it is really valuable to you. So please, I think you go to the VA medical facility and they give you the password that you use. And then every time you log in, I think it has to have a secondary confirmation, like text a number to your phone that you type in, but it is worth it. Please get that if you haven't.
Speeds things up for you a lot, and you're not waiting on the bureaucracy.
Yeah.
54 nights again. What does we close the notice for exam request processing mean?
That means either they got it or they decided they didn't need it.
Right. Bamboo Pandolif, good to see you. Korean War vet died after his prostate cancer metastasized, causing B-cell lymphoma, which is listed as immediate cause of death on death certificate. However, bilateral pulmonary embolism is listed as a contributing factor. Is it possible to appeal DIC denial, arguing his non-service connected pulmonary embolism was secondary to his service connected sleep apnea? Go back to the first part. Okay, so I'm looking at this and I'm wondering if he was a Korean War vet, if he was actually in combat, if he's anywhere near the DMZ. Oh wait, that precedes.
Yeah, that was before then. Immediate cause death, and then go to the next one, Nate, please. However, bilateral pulmonary embolism is listed as contributing to possible. Argue his non-service connected embolism is secondary. It's possible to argue it. I definitely research what causes bilateral or pulmonary embolisms and then see what he might have been or should have been service connected for. Remember, a DIC claim reopens everything. So you can file a new claim. You're trying to show cause of death was related. So you can file and allege whatever you think is a cause of death that should have been service connected. So I would look at anything they're service connected for and see if there's any way that it could have contributed to his cause of death. If he had heart problems, if he had breathing problems, I mean, there are lots of things that, would weaken your immune system. So I'd look at everything and see if there's a way to go through that. But yes, I definitely pursue that.
So it doesn't have to be primary cause of death.
No.
It can be a contributory cause of death. And that's the angle we're working for here.
Remember, caused or contributed to the death.
Twisted L, good to see you. If you are denied, but their reason for denial do not follow their laws, is that Q?
It's hard to say.
Yeah, so be careful with Q. You do not want to use Q if you have an open appeal. If you have an open appeal and they're blatantly not following their laws, this is where Carol loves to go do a CAR, which is it's a kind of a fast lane review of higher level review where it's just kind of error on its face. Q is just it's the last avenue. You have a closed claim. There's no way to reopen it. There's no other thing to use. Q is just such a high standard and a high burden of proof on you. You don't want to go near that if you don't have to. And if this just was denied, you don't have to do that.
Right.
Tiny, does the VA provide more leniency to claims under a Democrat or Republican president?
I don't see they provide any leniency one way or the other. This is a VA.
Yeah, I mean, it's interesting because, there's always political appointees, right? And that's at the top of the funnel. But the VA is such a big bureaucracy that a lot of times they don't
doesn't filter down.
Yeah, permeate. It doesn't go down. I mean, I will say, and Carol and I have dealt a lot with the Undersecretary of VA Benefits right now. We think he's the best Undersecretary we've ever seen. I mean,
he's incredible.
He reaches out to us. He asks us questions. We present him with what we think are, we gathered data from our veterans a lot on CMP exams and show how we think they're flawed. We presented quite a few different things to us, and he's been very responsive. And we think he's great. However, it still has to trickle down to in the VA itself. And neither administration really gets to push down on the bureaucracy.
Remember, the people who are in the VA often have been there 20, 30 years. They've been doing this their way, and they don't care who's in charge. They're going to do it their way. Right. They're government employees, so very difficult for them to get rid of them. And so they just do what they feel like is the law. And that's the problem. That's what you're dealing with. It is a huge organization. The people that have been there for a while are just, I got this and I'm going to do it my way. So you can't really say anything about what's happening recently because it doesn't affect them.
Yeah. And then as far as pointers going into a hearing to claims PTSD and lumbar, what to expect? I mean, this depends on what kind of hearing. Is this a hearing with the higher level reviewer, or is this a BVA hearing? I take it from a BVA hearing, they're not going to know your file very well. They're going to know what you're claiming, but they're probably not going to review the evidence. So you want to see what evidence in there is really favorable for you. Point that out, bring it forward. If there's something really unfavorable, then you need to present evidence that contradicts that or shows why it's not relevant or shouldn't have much probative value. for a higher level review hearing, I don't know, would you do anything else different?
Well, before you do any hearing, you need to find out what is the issue.
Yeah.
Remember, so many veterans will come in and they'll try to prove that they were in Vietnam where the government has already agreed they were in Vietnam. What they don't agree is either you don't have a diagnosis, you don't have any current medical records, or we don't have a nexus. That means we don't have anything connect what happened in service with what you've got now. So the first thing is you need to figure out what the issue is. You turn the judges off when you start talking about something that's totally irrelevant. If you're already agreed you're in Vietnam, if they already agree you have a pulmonary embolism, then they're going to say, but show me the connection. Why did this cause that? So don't waste their time. Figure out exactly what the issue is and go right to your evidence. Okay. I hate hearings. I think it's, you read them and you see, oh, somebody please shoot this veteran before they really ruin their case, because they'll start talking about stuff. They'll start talking about stuff and it just goes on and on. And you think the judge has just cut you off mentally. So don't do that. Figure out what's the issue, get on the issue, don't get off the issue, and don't go on and on. Here's the evidence. This is what it says. Okay, period.
And you should know what the issue is if your case was filed under the AMA, because they have to tell you what elements you've met. So for your lumbar, they got to tell you, did you have a claim? Did something happen in service? Do you have a current diagnosis? And is there a nexus? So they'll tell you, you have a diagnosis. We see that you fell in service. And then you'll know either explicitly or implicitly they're denying you because there's no nexus or link between the two. So that's what Carol's saying. You got to go right to, well, here's the link. I would mention, hey, the record already says that I have a diagnosis and there's an incident in service. Here's what they say is missing. Here's why they're wrong.
Right. And a lot of times it will say, here's another thing that you should be looking for. No chronicity. So that means you fell, you hurt your back in service, and now years later you have a back problem. There's no, it wasn't chronic. It didn't continue. So what you want to do is address that. Here's my witness. It says they knew me after service, right after service, or in service, saw me hurt my back. I couldn't play golf. I couldn't do any of these things from then on. I have suffered with it from then on. So you want to get your witnesses and you want to address only that issue if that's the issue.
The other thing I'd say, though,
you don't get to say it.
Well, if it's a higher level review hearing, you don't get new evidence.
No, I'm sorry. I didn't know which here. I was thinking the BVA.
Hearing it is. Right. Okay, good. Brian Quinn, I have file claimed. Can the VA make you take TDIU? I'm sure I'd be able to receive it. Just wondering if they can force you. I don't want to deny it, but finances dependent on working.
If you don't file for TDIU, they can't give you TDI because you have to fill out the 8940 form that shows when you worked, if you're still working, things like that. So for TDIU, you'd have to not be working, and it says you are working. So I wouldn't worry about that.
Wayne, how can effective date be appealed? I called the 800 number and notified my intent to file a claim. I checked back a couple months later, and the record did not reflect an intent to file. So, I mean, that's two different issues. You file the appeal on the appeal form. If you're filing a new claim, you filed an intent to file and they lost it. Well, it doesn't matter what you were going to file. They lost that. So
if you don't have any proof,
you don't have any evidence to send in, then it's their word, it's yours, and unfortunately they win. So
you do need, there's just a 1-page form, or it's 2 pages, notice of intent to file a claim.
But don't file that if you have an appeal to file. File the appeal itself.
Well, he's saying, how can effective date be appealed? You
don't
appeal.
want an intent, you're not filing a new claim. You're appealing a claim.
Right.
So that's 0996.
6.
Yeah. Rich Rod 1678. I'm going to file a claim for ED and complex sleep apnea. Should I submit also secondary conditions like diabetes type 2 and high blood pressure?
Always. Yes, always.
William, what can you do if the VA claims they called you for an informal conference, but they didn't call? I was supposed to have a higher level review informal conference.
I would send a letter in or on a 4138 Remember, that's VA 21-4138, and say, I was supposed to have this conference. I was never called. This happens a lot. And that's why I work on the weekends and I leave my phone on. And when I answer it, they're so shocked because they like to call on Saturdays, Sundays when they don't think anybody's going to answer the phone. So this happens a lot. You need to point that out and say, I want my hearing.
Just Fred. I have a CMP exam tomorrow that includes Tara medical exam. It's for COPD. I only have one entry in shortness of breath in dry dock, asbestos, AFFF, JP5, lead paint, and cleaning solvents. I'm hoping things go my way, but I'm not holding my breath. Well, don't hold your breath. Let's definitely start there. Yeah, let us know how that goes. I mean, that's quite a few things you're exposed to. So I would hope the VA realizes that at least one or two could have caused these problems. So,
and you want to, okay, so would you go back to one? So you're having the Tara medical exam. So they're going to want to know where and when you were exposed to all of these things. So you want to make sure you're clear on that. When was the ship in the dock when y'all pulled out the asbestos? Where were you and when you were exposed to the JP5? That really helps if you have that. And then they can confirm that.
Tiny. How does the VA deny claims when there's medical evidence? I've been denied twice now. Also, there's medical evidence in my service record. So again, you need to see exactly what they're saying. Are they contesting that there's no evidence in your service records? If that's the case, then you just bring up what your service record says again and say, what's going on here? Are they saying that there's no diagnosis and you have a diagnosis? Again, the records say that. Or are they conceding both those and saying, even though you have both these, we don't think they're connected, that there's no nexus? If that's the case, that's what you need to focus on. You see, what did the CMP examiner say? What did they not say? What evidence do they have in front of them? And what can you put in front of them to make them change their minds?
And I'm willing to bet that this is one of the chronic. They're saying, yes, you had a back injury, but it resolved. So the back injury you have now is new and not related. And so that's why you look at what they're saying in there and figure out, because you want to address just that. Everything else is taken care of. But that's the thing I'm seeing a lot of when people actually have service medical records that show back problems, knee problems. They're saying that it wasn't chronic, that it was resolved. And this is something totally new.
Craig, I was diagnosed with Parkinson's in 2009, left side peripheral neuropathy in 2010. In the Navy, I was a data systems technician from 79 to 94 using TriCore
left
TC. In 93, I had left side numbness, sign of pain,
peripheral neuropathy.
I checked Mount Tara memorandum and all have no. I found on the information on your website blog. What's next?
I think you need to write to them and ask them to correct your Tara and point out exactly what you did, where it was, and what you were exposed to. Because I've seen a number of Tara memos that are like that, and then they can be updated if you just give them the evidence. It's not necessarily that they would, but I have seen some of them updated. Especially what they were doing is the first ones, they were really looking at where you were as opposed to what you did. And I'm seeing the latest ones are really getting into down at the bottom, what was your job and what were you exposed to in your job. So I would definitely I would write that all out on a 4138 and submit that and ask for an amendment or revision to your Tara memorandum. Meanwhile, you need to appeal.
I'm also interested in, go back to the first part of this question.
Parkinson's 2009.
He said he had symptoms in 93.
Yeah.
So that's what I want. I mean, I want to know what symptoms you had, and can we get that documented either?
Would you go to the next one? Yep, left-sided numbness.
Yeah, so I was looking for some kind of chronic disability, but we don't even need that because he had symptoms in service. So you need to speak to that, and we will. If you don't have service medical records talking about that in service, then I think we need to get some kind of buddy statement. If any of your friends notice that you have weakness on your left side or any kind of peripheral neuropathy, or you spoke about it while you were in service.
But you need to do all those. You also need to get your Tara memorandum corrected.
Yeah.
Because that could lead to other benefits as well.
Ryan, I retired in April 15 and have 40% service-connected disability rating for my spine. I recently filed a claim for my cervical spine and bilateral radiculopathy. Had a CMP exam in June and just received a notification that it had been sent back for further evidence, and another ACE CMP exam to see if it's secondary to my lumbar spine. Can I upload additional files for the ACE exam? Yes. Should I be concerned about my claim for my cervical spine? We don't know. I mean, again, when they send it back, either they didn't ask the right question, the wrong question was answered, wasn't enough information. But yeah, it's a great idea to send in more info if you have it. William, could me having 2 open higher level reviews of denials years ago jeopardize my 100%? It shouldn't, unless they're on the same issue that you were granted 100% for. I don't.
Years ago jeopardized? No, and they shouldn't be open years ago. If you have higher level review, how can you have open higher level review denials?
I don't know either. I guess he appealed them to the board.
Yeah, and I don't think that would jeopardize it. At any point when you meet the 100% permanent total, they're going to, and they're working on that issue, they'll grant it. What's in the BVA doesn't necessarily affect that at all.
Tough dog. Service connected for fibro, service connected for IBS. I've been diagnosed with problems that are symptoms of both, i.e. migraines, mental health, chronic fatigue syndrome, etc. Can I file secondaries? Yes, you can, because those use different diagnostic codes. They present different symptomatology. So yes, therefore you can get, not only can you file, but you can get rated on those. And honestly, those ratings would probably be higher
than what you've got
you're getting, for the ones you have right now. So
right.
I would highly recommend that.
It's trough dog.
Trough dog?
TRO.
I add letters, subtract letters. However, roll twisted L. Does ANA for mental health condition mean that it will raise an incompetency issue, or is incompetency based only on finance?
It will raise competency only in that the ANA form, the form they fill out for aid attendance, says, are you competent to handle your own funds? And that's the competency question. If they put, yes, you can handle your own funds, they won't bother you.
But yes, incompetency is based just on finances.
Yes. They can say you have a memory problem. You can have all sorts of mental problems. You can be bipolar, but as long as you can handle your own finances, there's no problem.
Eliezer, hello. Thank you for what you do. You guys are amazing. I was awarded my back condition at 10% and radiculopathies at 10% each. I know I'm not properly rated. They never used my x-rays. At this point, we want to talk about the back is such I loathe how they rate the back. It just has no real connection with how your back limits you. Because they want to know how far forward you can bend to the side and all this nonsense. And they're not talking about how does it limit you on your day-to-day basis. The radiculopathies, I think, might be more ripe for a higher rating here. You got to talk about what kind of weakness. Do you have numbness? Do you have pain shooting down your legs? Those are things you kind of want to dig in on. Your back might be misrated, and hopefully you can get up to at least 20, but getting it up to above 20 is really difficult. Whereas I've personally found that getting the radiculopathies correct is a little bit easier.
So they rate your back on the big rating is how far you can bend forward. You're standing up, you bend over toward, you touch your toes. If the more limited you are, the higher rating you get. So if you're very flexible and can go down and touch your toes, even though the pain is supposed to stop you at some point, and that's where they give you the rating. But with your legs, you can show you have weakness, pain, numbness, your legs give way, you have foot drop. There are all sorts of things that can really get your radiculopathy, that the pain, the numbness that goes down each leg, to get your ratings up, because you get separate ratings for each of those. I would say that all looks really low, and I definitely, they don't use the x-rays. They don't really use the MRIs. Right. That's unfortunate, because a lot of times they'll show there's stenosis. That means that the nerve is being encroached. And so you probably do have pain going down your legs, but they don't seem to pay any attention to that. It's all is from the examiner's review of how limited they think you are in bending over, and whether or not you have pain, numbness, weakness in your legs. If you can get your doctors to note that, I think that's really important, because a lot of times the examiner will look at the medical records, and if it shows radiculopathy on both sides and it shows severe problems, then they're kind of in a bind. They're going to have to show there was some radiculopathy, and then it's just the amount. So anything that shows that, I would bring with you to the examiner. Not a lot of stuff, but just that. Thank you.
Stephen, your firm is awesome. How does one get their SMC L.5 increased?
Well, we would have to know why you have SMCL in the first place, because this SMC, special monthly compensation, is like everything in the VA, very complex. And it's built on, it's not like you're rated 10, 20, 30%. It's built on specific disabilities or problems. And so for each one, you get a letter, and then they have a way of combining letters and half combining letters. So you get up to L1.5 or L.5 or M or N.5, but they're all built on something below it. So I don't know what you already have to tell you what you need to get more. I'm sorry.
I mean, we'll say, for instance, if you have something that aid in attendance is SMCL. So if you have one disability for which they granted aid in attendance, and then you have another disability that's 50%, well, then that's why you got the half. If that other disability or other disabilities combined 100%, then you can get a full notch up to SMCM. But I don't know.
But you could have had, to get L, you could have had a bunch of Ks and some other things.
Yeah. So, without knowing the underlying disabilities.
Yeah, you don't have aid in attendance. That's what we're saying. We don't know what those letters are made up of.
Chocolate Goddess, thank you for all that you do. Question: my buddy's statement was just typed and signed. Will the VA accept it? I want my superior to do one for me as well. The easiest thing to do is to get them on a 4138. If you already have one signed, maybe you take a 4138 and act as a cover letter and just say, this is have the person say, this is my signed affidavit attached. In theory, they should take it. You could get it notarized. That way they would have to take it. But the
take it doesn't mean the same as act on it.
Right.
So I'm telling you, so you understand what's normal. Normal is the regional office won't pay any attention to what you say.
No matter what it's on.
Or matter what it's on. The thing is about having it on a 4138 or the 102, whatever the new forms are, is at the bottom it says, I certify this is correct. It's sort of like having it notarized without having to have it notarized. So I think anything you think is helpful for you should get on those forms, submit them, and then the BVA most of the time will look at those and they will send the case back telling the regional office, you didn't pay attention to this and you need to, so redo it all over again. So yes, I think they're very helpful.
Richard, how long can you reuse a DBQ?
Until they replace it. Periodically, they'll put out new DBQs, and any DBQs that are dated before that are now no longer considered valid.
If you have a DBQ that's been filled out, filed with the VA, and
I thought he meant updating.
Yeah. I don't know. But if you have one for you specifically filled out and you submitted it, I don't know that you can, if they didn't use it to grant you benefits, you can keep appealing. But once that appeal stream's ended, you're going to need a new one.
Right.
Twisted L. Is it allowed to state the M21 or CFR directly in a personal statement? Sure. Yeah. I mean, that's basically what we're doing in our email letters. TCLE. I have a higher level review, supplemental, and C-file request. Couldn't they do a supplemental right now? It seems like they're waiting for all three to be together in one decision. They've done things like this before. The supplemental should go with a different adjudicator than the higher level review is. Higher level review is specifically you're getting someone more seasoned, like a former decision review officer, versus the supplemental goes right into the line adjudicator. So they won't combine those.
And the C-file request goes to someone else too. So all three.
This is the VA.
Yeah. So it goes to three different people. So it has nothing to do with each other.
They all go in the same front door and then they disappear from there in different directions.
Different trash cans.
Right. Mad Cow Como. Hypothetical. If a veteran was in a vegetative state and was 9.5 years, 100% P&T, could the wife keep the veteran on life support for 6 months in order to qualify for DIC benefits? Would that work?
Well, that would definitely work. But the thing is, if what put them in a vegetative state was service connected, they wouldn't need that to work anyway.
Or they're service connected. You could argue their service connected disability contributory cause the
vegetative state.
Well, death.
And the death. Yeah. If he's in a vegetative state, that's probably what's going to cause his death. So if that's already service connected, then he or she is already covered.
But if it's not, hypothetically, Yes.
God.
6 more months. Bob W. 2 of 2. Which would be better? Submit 4138 describing the discrepancy and request a new C&P exam, or request a higher level review? To whom would you request the new C&P exams would be my question. I think you would want to file a higher level review and point out that
as
C&P
all
exam
part
is
of it.
inadequate. Right.
Yeah.
Jason, if a veteran is 100% P&T, do the 5, 10, 20-year rules still apply? Yes. Also, will 100% P&T, they be grandfathered in for any new law changes? Lawyers giving free advice for an hour. Wow, thank you. Carol, what about that second question? Should they be grandfathered in for any new law changes? I think as long as they don't.
Yeah, as long as you don't go back and file anything new, they're not going to
asking for an increase. Then
right.
They shouldn't be reviewing it. So I think you should be fine there.
Yeah.
Chris, received my higher level review result. They increased my rating from 10% for my vertigo to 10% for vertigo with an effective date on the date of the C&P exam, not the notice of intent to file. How do I correct the effective date? So if this was higher level review, unfortunately, you have one of two options. You can go to the board or you can file a supplemental claim. But the supplemental claim, you need new and relevant evidence. This is super frustrating that they did this. They're assuming that all of a sudden, even though you filed way back then on your intent to file that things were bad, they're saying, oh, well, things didn't get bad, so you had the exam. They do this all the time. This is a way they take your money.
If they go, well, how did I know it was worse? I just have proof right this date. And they do it over and over again. So no, I'd appeal it. And then the question is, you can file 2 appeals. You can file for an earlier effective date. And then you can also file a supplemental claim asking for a higher, or you can file to the BVA for a higher rating for the vertigo. So this is the one thing you can do with this new AMA is you can split these 2 issues. So if you feel like you'd rather go get more evidence to show vertigo, you can either get it within 90 days and send it to the board, or you can, if you don't do it, just send the effective date to the board and work on getting that evidence and filing a supplemental review.
Yeah. It would be faster to get a supplemental claim here, but if the idiots miss this twice, then
I
wouldn't miss it again. Yeah.
Regarding the effective date, I think you really need to go to the board.
This is frustrating because it's just it's such a blatant grab, I think, veterans' money, but don't let them do it. Twisted L, have a question about combat-related service compensation. For future reference, do you guys have knowledge to share about combat-related service compensation or just VA claims? We really do just VA claims. A lot of our cases get sent to DFAS, which is the organization in the DoD that does offsets for anyone receiving compensation or pension from the DoD.
And they make the decision.
Yeah, they make the decision. But if the person already has recognized compensation that is related to combat
PTSD,
then there's no offset. Then they receive both their DoD pension and the VA benefits. But we don't make those determinations.
And we don't really get involved.
We get the decision without us even being involved. The VA has already sent it off to the DoD without giving us notice. City Nights, is it possible to receive ANA for 2 disabilities, example, mental health and sleep disorder like hypersomnia, not related to mental, and receive SMC R1?
I don't know about 2 mental.
Yeah, that would be hard, I think, because they consider that pyramiding. But it is possible to get aid and attendance for 2 different ones. And you point out a really good point here in that you do a massive jump. If you get aid and attendance for issue A and then aid and attendance for issue B, aid and attendance is SMCL, which pays, let's call it 4,200, 4,400.
47, 48.
Oh, it's 47? Mm-hmm. Inflation. 4,700 a month. R1 is in the 8,000s. So
close to 9.
Yeah, it's a pretty massive jump there.
So we just got for our veterans, and this is hard to get. I have not seen it. We've been trying to get it. We just got R1 for our veteran by an aid and attendance necessary for mental and aid and attendance necessary for physical. And those are something you really should work toward. Because I would think they would be easy because they're so easy to separate the problems and the limitations that they cause.
Sleep apnea would be different, but sleep disorder is going to be rated under the same diagnostic code as mental health, unfortunately. So Yes, it is possible, but you just got to make sure you're not pyramiding to disabilities.
I think sleep apnea is, I think that's just going to be really hard.
It's going to be hard. Yeah. Well, it's going to be hard no matter what, because they realize what's at stake.
Yeah.
All right, Timothy, I have total of 70% lower back strain radiculopathy in both legs. I'm waiting results for TDIU. Today, I was diagnosed with venous insufficiency and will have closure fast procedure next month. Should I file a new claim or wait for the results from TDIU? You should file. Yeah, you should file a claim now because that's in play right now.
Yeah. And that, remember, it doesn't, like we just told you, there's a higher level review, there's a request for a C file, and there's a supplemental claim. They're all going to different people. So the fact that you've got those all three going doesn't affect the other. And that's the same. This would be a new claim. Mm-hmm. And the TDIU is with somebody else. So please always file.
Get that going.
Yeah.
All right, Nate, I think we do about 3 more questions here. Dave, hi, 100% P&T for PTSD alone with SMCS statutory bound status. I have 90% for secondary conditions. Am I allowed to earn any income, saying from buying and selling items online?
If you're 100%, period, you have 100% for PTSD or combined 100%, then you can still work.
It's the TDIU that could raise
the
flags.
TDIU means you have to show you're not working.
Right.
And a service-connected problem keeps you from working. So those are 2 separate things. 100% scheduler combined, you can make millions and still get these benefits.
Wayne, I will be filing for an increase in PTSD soon. Can I simultaneously file a claim for ED secondary for PTSD medications, or should I wait? File them all at the same time. Please
don't wait to file these secondary, because like hypertension causes strokes, it causes chronic kidney disease, hypertensive heart disease. And the VA, when you file for hypertension, that's all they're going to look at. And then when you go and say, but I have these, they're going to say, well, then file a claim. Right. And then they're going to say the effective date is the date that you just filed this claim. So please file everything. And you can say heart, secondary to, whatever, secondary to, but file them all. I'm getting a t-shirt.
File it all. File right now. Chris, I'm rated 20% for gastric ulcer with GERD. Can I claim IBS separately from GERD? My last endoscopy showed an ulcer, and I have medical entries for abdominal pain.
Those are a lot of the same thing.
You can file it. My concern would be with the symptomatology and the rating, would they overlap, and then they just call it a pyramid.
Right.
With the new ratings, I'm not sure that they pyramid now, but I haven't had a case on that yet.
Yeah, I haven't had them either. So.
All right, folks, that's all we have time for today. Sorry for the shortened session, but we appreciate you coming. Again, it's always good to see these thoughtful questions. You guys are doing your research. Knowledge is power, and that's what's going to get you the benefits you deserve. Until next week. Well, actually, we're not here next week, I think.
Right, we're at the NOVA seminar.
Yeah, so hopefully we're going to get some updates from the VA on y'all's favorite questions. How long is it taking? What's the BVA, doing?
What's going on with the BVA?
Yeah, so hopefully we'll have some updates to share with y'all the following week on that. So thanks so much, and we will see you then.